All right, let's jump right in. We're going to look at a dispute that on the surface seems pretty small time, a disagreement in a quiet neighborhood. But it actually ends up asking this huge question for our digital age. It's all about a single phone call, a personal cell phone, and a legal fight over what counts as an official record.
And this is the million-dollar question, right? This is the whole mystery we're unpacking. When a manager for a homeowners association uses her own personal phone for work stuff, does that call log, that simple list of numbers and times, suddenly become a public record that any homeowner can demand to see? Well, let's find out.
So, our story kicks off, like a lot of these do, with a homeowner and his association. A guy named Oren Snir made what he probably thought was a totally normal, straightforward request for some information. But, as you can guess, it got complicated fast.
It all got started back on April 23, 2025. Mr. Snir sent an official request to his HOA, the Gila Springs Association. All he wanted were the candidate forms or other expressions of interest for their board election. He was just trying to see who was running for the board. Seems simple enough, doesn't it?
But here's how that simple request just completely spiraled out of control. Literally, the next day, the HOA gets back to him and says the only other candidate just called to say she was interested. No forms, no emails, just a phone call. And that's when things got sticky. By June, Snir discovers that this wasn't even a call to an office phone, it was to a manager's personal cell. And by December, boom, they're all in a formal hearing, arguing in front of a judge.
So let's break down Mr. Snir's side of things. His case wasn't just about this one election. No, he was really pushing for a whole new, modern way of thinking about what a record even is, in a world full of smartphones and people working from anywhere. And this quote from the hearing, it just perfectly captures the heart of his argument. He's basically saying, who cares if you used an office computer or your personal iPhone? If you're doing official business, the record of that business belongs to the organization. The what is what matters, not the where.
Snir's logic here was super clear. This phone call was about a board election. That's about as official HOA business as it gets. So any record that came from that call, in this case, the call log sitting on the phone company's servers, well, that should be considered an official HOA record that members have a right to see. And to drive this point home, he used this really sharp analogy. He said, look, HOAs have to hand over official emails, right? But they don't own Google servers, or Microsoft for that matter. Those records are held by a third party. So why would a call log held by another third party, like Verizon, be any different? It's a pretty powerful point.
But of course, the Gila Springs Association saw things completely differently. Their whole defense was about drawing a very thick, very clear line between what belongs to the association and what belongs to the people who work for them.
The HOA's lawyer, Austin Bailio, pretty much laid it all out. He argued that just because their managing agent creates some kind of record while doing her job, that doesn't automatically make it the HOA's property. They insisted there has to be a distinction.
So their defense really came down to 4 key arguments. First, a call log is just numbers and times. It doesn't actually show an expression of interest like the original request asked for. Second, the HOA never had the record in its possession, custody, or control. Third, it was a personal record of an employee, which a specific law says is exempt. And then, their final kind of trump card, hey, the records don't even exist anymore.
And that last point was a really big deal. The manager who took the call, a woman named Mary Jo Edel, she testified that she'd since retired, she switched her phone plan, and she just flat out couldn't get the call logs from that time anymore. So the HOA's argument was, even if you sided with Snir, how can we possibly produce something that's just gone?
So there you have it. 2 really compelling modern arguments. On one side, you have the idea that business is business no matter what device you're using. And on the other, this hard line between corporate and personal property. So, how did the judge land on this one?
In the end, the judge sided with the Homeowners Association. Oren Snir's petition was officially denied. But the why, the reasoning behind that decision, that's what's really fascinating here. The judge basically broke it down in 3 logical steps. First, the HOA did everything right when it came to Snir's original request for documents, like forms or emails. They responded on time and told him, hey, there aren't any. Second, and this is the big one, the judge ruled that a call made on a personal phone doesn't just automatically create an official HOA record. And so third, if it's not an official record, the HOA didn't break any rules by not handing it over. So, while this particular case might be closed, it really cracks open a much, much bigger conversation, one that affects pretty much all of us. This isn't just about one guy in Arizona. It's a perfect snapshot of a huge issue we're all dealing with.
What this dispute really highlights is this growing friction, this tug of war between our laws, which were mostly written back in the age of file cabinets and office landlines, and the reality of how we live and work today. Our technology has just leapt ahead of our rules, and that's creating all these messy gray areas.
And that leaves us all with this final, really challenging question. I mean, think about it. As our work life just completely bleeds into our personal devices, when you take a business call on your cell while you're driving home, who really owns those digital breadcrumbs you're leaving behind? This case gives us one answer, but it's a question we're all going to be grappling with for a long, long time.